So the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, this was another dead-letter amendment like the Third Amendment for many, many decades. If I had to take a guess, it was probably maybe the 60s or 70s where the debate that we're still having today over gun rights came along. So the modern debate, though, really focuses on whether or not an individual has a right to keep or bear arms, or whether the Second Amendment was only meant for militia organizations, and there aren't any militia organizations like in that way. They're talking the National Guard. So the founders, the founding generation, they were of the firm belief that governments are prone to use their soldiers to oppress the people. And, well, that can be very well understood because soldiers had just been used to oppress them. We talked about the Third Amendment at the end of last week before you took your test. Soldiers were being quartered in the homes of colonial Americans without their consent. Yes, they were being used for oppressive purposes. But English history, everything in this class I can tie back to England, suggested really that this risk could be controlled by permitting the government to raise armies, full-time anyway, only when needed to fight foreign adversaries. So we would only have a full-time standing army if there was a imminent risk, we had been invaded, etc., etc. There are flaws, well, more than many, numerous flaws with this line of thinking. The biggest one being, if you find yourself in need of a full-time army, it's too late, one, and the people who were in your army the last time, they might have died, they might have moved on, become too old to serve, etc., etc. So this was a flawed way of thinking, certainly. But this is how the English did it for many years. So for other purposes, though, they wanted, the English, we're still talking about that, a militia of citizens to respond to sudden invasions, like I was talking about a moment ago. They depended on, were fans of having militia organizations do the work of repelling invaders. These militias would get some part-time unpaid military training. They would supply their own weapons. This worked, when it was musket on musket. Wouldn't work so well now if, say, the Russians invaded with fighter jets and destroyers and, we're out here with our pistols and shotguns and things like that. It worked only really when the force that the citizenry could exert was equal to that of the foe. Again, as I said, the onset of war certainly does not allow time to raise and train an army. Well, not always anyway, but I would think a sudden war would not. And the Revolutionary War, our Revolutionary War, showed that militia forces could not be relied upon for the national defense. Now, militia forces were what won us the war, really, but there were a lot of problems with that. For instance, I can think of one. They left. Their contracts were up. They got fed up with it. There was nothing keeping them there. They could just leave Washington's army. So the Constitutional Convention decided that the feds, the federal government, should have the authority to establish a peacetime standing army and also to regulate the militia, which again becomes the National Guard. And this shift in power from the states to the federal government, again, remember, before we were under the Articles of Confederation, it was the states that were handling a lot of these things. It generated a big objection to the then proposed, it wasn't adopted yet, Constitution. The Anti-Federalists, the people against this ratification of the Constitution, thought that a proposed Constitution was going to take away from the states their principal means of defense against tyranny. If the feds decide suddenly, well, Georgia is not following X law in the way we like, let's send in the army, well, the Georgians wouldn't have any way to fight back against that. It would be like Great Britain and the king all over again. So the Federalists, they said that fears of oppression were massively overblown because, one, the American people were armed and would be almost impossible to subdue through pure military force. And that was true too, again, but we're talking about the age of musket versus musket. So they agreed on a couple things, these two rival camps. One, the new Constitution gave the federal government almost total legal authority over the army and militia. And two, the federal government shouldn't have any authority at all whatsoever to disarm the citizenry. The disagreement came here when they started to discuss whether an armed population could deter any sort of federal opposition. And the answer back then was yes, and it's become not so much as the years have gone by. The Second Amendment gave nothing to the Anti-Federalists' desire to curtail the power of the federal government, the military power. It did nothing for it. That would have required substantial changes in the original Constitution, but the amendment was accepted anyway by the Anti-Federalists as well because of very much widespread agreement that the federal government should not have the power to infringe on people's rights to keep and bear arms, any more so than they should have the power to abridge the freedom of speech. These rights were equally as important. Everything in the Bill of Rights is equally as important. So these are fairly obvious. But there have been the changes since 1791. We don't have militia organizations like we used to anymore. They're in the National Guard units now. The militia organizations by the states were eventually incorporated into the federal military structure, and certainly they are. They're trained soldiers. The military establishment has become enormously more powerful than 18th century armies. That's true. We didn't really have a military establishment before, World War II. Around World War II was when we started to see the development of the modern-day military establishment. We still really hear this political rhetoric about federal tyranny. Most Americans, though, don't fear the nation's armed forces, and you shouldn't. No one also thinks that an armed population anymore could defeat the American military in battle. They couldn't. So the founding generation, 18th century civilians, they kept at home the same type of weapons that they would need if they were called on to serve in the militia. Granny would have a musket above her door. Your uncle would have a pistol in his living room. These were the same weapons that officers in an army would have. So modern soldiers, though, are equipped with weapons that are very much different than what is thought appropriate for civilian use. And civilians no longer expect to have to use household weapons for militia duty. Wouldn't really work. You need a little more heavy-duty stuff for National Guard. Although we still keep and bear arms to defend against criminals, go hunting, whatever, etc. And the law has also changed So states in the founding era did regulate guns. The regulation, though, was like this. So you'd go down to the town square on maybe a certain day, just depends on how your village did it, and they'd say, hey, Parker, how many guns do you have? Well, I've got 2 muskets and a pistol. Okay, they write that down. Jonathan Parker, 2 muskets and a pistol. And that would just be maybe in case my neighbor or someone who lived in another part of the town didn't have adequate means to defend themselves. If the Indians came or we were invaded or whatever, they could say, go see Parker, he's got an extra gun for you. That was the regulation. Obviously, it's much more extensive now. African Americans were still slaves in 1791. They were oftentimes prohibited from possessing firearms and militia weapons. Gun laws, of course, today are much more extensive, much more controversial. And another really important legal development that we need to mention was the adoption of the 14th Amendment. That was a game changer. The Second Amendment applied originally only to the federal government, and the states could regulate weapons as they saw fit to do. Although there was really no evidence to suggest that the Privileges or Immunities Clause of the 14th Amendment was meant to protect the rights of individuals, to keep and bear arms from state infringement, the Supreme Court rejected this interpretation in United States versus Cruikshank. And don't worry about that. That one isn't going to be on the test, or the final at this point now. And until recently, I mean, as I said at the beginning, the judiciary treated the Second Amendment really as a dead letter. It meant what it said, and said what it meant. In D.C. versus Heller, though, the Supreme Court invalidated a federal law that forbade nearly everyone in Washington, D.C. from possessing handguns. And this is what's going to be on the test. Certainly, click on this. Again, I'm probably going to get claimed if I click on this. So this takes you to the Supreme Court website, where you can look at D.C. versus Heller. Again, I do concentrate heavily on this for the final, or whatever test I'm on when I get to this in a semester, but fall 2020, it's the final. So no D.C. versus Heller. Know it. So a 5-4 majority said that the language and history of the Second Amendment showed that it protects a private right of individuals to have arms for their own defense and doesn't give a right of the states to maintain a militia. The dissenters disagreed. They went the other way with it. They thought that the Second Amendment maintained that the people had the right to maintain a well-regulated militia, and, that owning guns on your own, it was a nominally individual right, but the Second Amendment doesn't really protect it. They said, the dissenters, even if the Second Amendment does protect an individual right to have arms for self-defense purposes, it should be interpreted, it should be okay for the federal government to ban handguns in high-crime urban areas like they did in Washington, D.C. McDonald versus City of Chicago was a very similar court case, although don't worry about that. I might ask you the name of it to name it. I don't think nothing about it's going to be on there, though, because it did largely the same thing. And Heller is the one that we look to in political science. So they struck down a handgun ban, too, at the state level by a 5-4 vote. So 4 justices in McDonald versus City of Chicago relied on judicial precedents under the 14th Amendment's Due Process Clause. Justice Thomas, rejected those precedents in favor of the Privileges or Immunities Clause. All 5, though, in the majority concluded that the 14th Amendment protects against state infringement of the same individual right that the federal infringement, that is protected from federal infringement by the Second Amendment. So in this case, the state of Illinois can't tyrannize you or infringe upon your rights any more than the people in Washington, D.C. can. So these are both very lengthy opinions. The bottom line is that they technically rule that government may not ban the possession of handguns by civilians in their home. Heller gives this list of presumptively lawful regulations, including bans on felons possessing firearms, mentally ill people possessing firearms, bans on carrying guns in sensitive places like schools, government buildings, churches, laws that restrict the commercial sale of arms, bans on concealed carry, bans on weapons not typically possessed, direct quote, by law-abiding citizens for lawful purposes. So I'm imagining they mean something like a bazooka or a rocket launcher, something like that. Many of these issues remain open. The lower courts have disagreed about what some of them mean, or if there even are issues, including very important questions involving restrictions on carrying weapons in public. So this video, I pull many test questions from for the final. Watch this again and again and again and again. There are a list of definitions in the at the bottom of the video, in the description below, like stare decisis, for example. That would probably be on the final. The vocabulary words there in the description underneath that video are right on the money, and something I would also strongly encourage you to look at. So watch this video, and after you're done watching the video, watch it again and watch it again. I mean, stuff is going to appear on the final right from that. So that is all I've got for you for the Second Amendment.